Hold on. I didn't do my snap. Gabos.
All right, we are back on the record. The state of Texas versus Cameron Johnson. In cause number, let me go ahead and give you your conditions, sir. Do not pick up any new law violations, no drugs, no alcohol, random urinalysis. Do not leave outside Harris County. And I notice I'm not saying particular counties, I am stating it's only located in Harris County, unless you've been ordered and given court permission. Uh, In addition to that, the court will also be placing you with GPS monitoring device 24/7 house arrest. If you have employment or you're attending school, provide your attorney with a letterhead saying the days and times that you will be working or going to school. And the court will review that and make a determination whether or not that can be approved. As it relates to cause number 1796093, the felony possession of weapon that you allegedly picked up while you were on bond. The court's going to set that bond at $200,000. In cause number 1796046, then unlawfully carrying a weapon, the previous felony conviction that you allegedly picked up while you were on bond. The court's going to set that bond at $300,000. As it relates to cause number 1739192, the case that you were on bond, this court gave you conditions. One of those being not to pick up any new law violations, also not to have possession of firearms. The court is going to set that at a zero bond. Is there anything else on your side?
No, Your
Honor. Nothing at this time.
Thank you so much.
Thank you, Judge. Thank you.
Shout out to the Conspiracy Thug channel. They're the ones that put up that information and the bond footage and everything. So check them out. Real quick, man, because I'll play what the lawyer did to basically destroy the prosecution. We gotta make sure that we understand something. If you feel somebody did a crime, that's cool. If you feel that Lil Kim shouldn't get a bond, that's cool. But just because you feel that way doesn't mean that that's what the courts have to do. See, it's on the prosecution to basically go, this person doesn't deserve a bond for this reason. And unfortunately, or fortunately, whichever way you lean, I'm not going to tell you which one, they didn't do that. Cuz went there and got spanked. I like aggressive intellect because basically it's telling you, don't talk to me, shut up. I know what I'm saying, I know what I'm doing, I know what I'm talking. And that's essentially what he did. Now, we do have to sit back and we got to go, well, why was it so secretive how Lil Kim's lawyer was moving? Well, in all actuality, the man did what he had to do for his client, which means use all means necessary to get his client out of court. Now, what he didn't get is a gag order, so he can say whatever he want to say. He can jump on live and all this stuff and everything and say, see, y'all got it wrong. But basically, Lil Kim was caught with a gun under the seat, which means it wasn't really on him. And this is one of the things that more lawyers are using, especially when it comes to stuff out of California, because though it was in Harris County, he still had the stuff in LA. That's what they were using to hold him back. But that's also at the same time, like the NBA YoungBoy case with the Fed case, he has to be in possession. You have to have the gun on you, because the lawyer made a bunch of great points. But enough of me talking. Y'all check it out. Make sure you subscribe, turn on that bell to stay notified. I appreciate y'all hitting that like. We need 3K, man. We are literally only 200 away from 120K, but that's 80K away from 200K, man. So do your update, man. Hit that subscribe, and I'll catch y'all on the next one. I got some info on DJ Pat's lawyer that I think is pretty good. You might want to hear it. But once again, like I said, shout out Conspiracy Thug. They was the ones who put out the video first, and I got it off their channel and everything like that. So check them out. Give them the credit they deserve. I'll check y'all out in the next one.
Proof in this case, evidence of the circumstantial act of possession of a firearm. They've offered up that Cameron Joshua was arrested on a warrant. However, what they demonstrated is strictly circumstantial possession. By that, I mean, there's absolutely no affirmative link between Cameron Joshua and the gun found in the vehicle. They failed to articulate any control over the weapon, any actual knowledge of the weapon, any possession of the car, any link to the car. In other words, Cameron Joshua could very conceivably have simply gotten into somebody else's car with a gun underneath the seat. They haven't demonstrated any furtive movement, any attempt to conceal the weapon, any possession of the weapon beforehand. Under the law of affirmative links, Judge, this is tenuous at best. The crime of carrying a weapon requires that the person actually, exercise care, custody, control, and management over the object. While they've demonstrated that he exercised control over the car, they've wholly failed to demonstrate any knowledge on his part that the weapon was there. As such, Judge, we'd argue that the evidence is wholly insufficient to justify holding him at no bond. There is going to be some argument, I anticipate, about this issue involving California. The state has offered in the evidence in support of this charge in California what is appears to be a recitation of a docket sheet. I had a chance to look at it last night, and I've had a chance to look at the California Penal Code. It is unclear to me whether or not Cameron Joshua has been charged with a felony or a misdemeanor in California. What I see in the docket sheet is that he's been punished with 180 days in the county jail, probated for 2 years. In one section of the docket sheet, it references California Penal Code section 487A, which says that it can apparently be punished as a felony or as a misdemeanor. It is an offense of grand larceny. I've talked to several California lawyers trying to wrap my mind around it, but the reality is that this document that they're introducing in support of the problem in California does not definitively state that it's a felony. The reason that's significant, Judge, so my understanding is that the warrant he was arrested on was for felon in possession of a firearm. Yet we don't have any supporting documents to demonstrate that it was actually a felony that he was on probation for out of California, which would serve as a predicate offense for this offense. I would submit, Your Honor, that if in fact he was not a felon at the time of the possession of this case, his act of carrying the weapon is not necessarily a violation of the law, although it may be a violation of the condition that the court imposed as part of his prior probate or his prior release on bond for the felony offense of possessing a fake ID. Given the circumstances, we would submit that there are more than sufficient conditions that the court can impose that can satisfy the court's concern about public safety, and that the court should consider granting Mr. Joshua a bond and imposing conditions such as home confinement or a curfew or an electronic monitor to justify any concerns this court might have about safety. But given the circumstances the state has offered up, we'd submit it's woefully insufficient to justify holding him and denying him his liberty, interest, and bail.
Thank you so much, Counsel.
Yes, Your Honor. As I'm sure the court's aware, the burden of proof for purposes of this hearing is the preponderance of the evidence standard. You heard from Officer Del Bracolo that he observed the defendant in that vehicle. He was the sole occupant, the driver of the vehicle. Therefore, he had the keys to that vehicle. He stated that he observed the defendant with that car previous to that as well. That establishes that he had possession, or that was his car. You heard Officer Del Bracolo tell us that he found that firearm underneath the driver's seat where the defendant was located, and there was no one else in that vehicle. Furthermore, regarding the defendant's California felony conviction, if the court goes through State's Exhibit number 5, which is the docket entry from the defendant's California case, You will see that California codes that grand theft as a felony. There's the letters FEL for felony in those court records. Additionally, this court ordered the defendant under his bond conditions not to possess any firearm for the purposes of keeping our community safe. The defendant clearly violated this court's condition that day when Officer Del Broccolo arrested him on his warrant for possessing a firearm and found him with another firearm. So, Your Honor, I would ask the court to hold the defendant, revoke his bond and hold him at no bond under 11B of the Texas Constitution in cause number 1739192 and set sufficient bonds in cause numbers 1796046 and 1796093. Thank you.
Thank you. It's kind of recess until we move back.